I'm Laura Harbison, broker-owner of Realty Executive Southern Nevada Properties, and this is Real Estate Today. And today I have Kerstan Hubbs with Essential Legal Services here to talk with us a little bit about how to hold title to your property, the different types of vestings and what they mean and what they can do for you. So hello, Kerstan.
Hi, Laura.
Thank you for being here today.
It's my pleasure.
Yeah. So can you tell, I know there's a lot of different ways you can hold title to your property, and can we kind of go through each one and what each one, what each one means?
Sure, though I would love to do that, particularly because a lot of time what happens with individuals who are closing, and you most likely know this, Laura, because
they have to pick their vesting.
I know you go in person at a closing with all your clients, which is wonderful. But I was also going to say at closing, usually when you're closing, you're taking a deed. And they're telling you how your title to property will be vested. And if you were to question that at closing, the answer typically is told to you, that nobody can inform you as to what that means.
Right. The title company is neutral, and they say they are not an attorney, they cannot give advice, and if they have a question, they should talk to their attorney.
That is correct. So that is often something that's overlooked with individuals. They just will take the document, sign it, because you're signing so many papers at your closing. But it's an extremely important document. And if you ask a lot of people out on the street, most people don't know how they hold property. It's interesting when you and the way, and when I get clients that come in my office, I will ask them, how do you hold that property? And they'll say, oh, I hold it as tenants in common or something of that nature, and it's totally different at the recorder's office. So it's important to go over that. In Nevada, we have a very interesting vesting mechanism called community property, because we're a community property state.
Right.
You're going to see that outside of a lot of jurisdictions, or if they're recorded in different areas, are not familiar with community property. But that is typically for individuals who are married. And I highly recommend when they take property and they want to do it as a joint endeavor for their marriage to take it as community property. Similar to what we'll talk about in a little bit, joint tenancy, it does have a survivorship interest if you want to add it. So you can take the property as community property, husband and wife, each with a 50% interest in the property, each to leave and bequeath the property to whomever they would want over time. Or they can choose to grant each other a survivorship interest, whereas if one should pass, the property would freely flow to the other.
Right. So typically they would do option A if they have separate heirs.
True. That's a very good point.
That comes up a lot.
It does come up a lot because 50% of marriages at this point in time do not make it, and some individuals will remarry with two separate families. And so community property is a great way to vest title if you're buying with your new husband or wife, because you can leave your half to your heirs, and he can leave his half to his heirs. So that's a unique feature to Nevada that I like to talk about. Individuals, too, may take property as their sole and separate property. This is kind of interesting, but it's something that we need to look at. Typically, individuals will do that if they're trying to send a strong message that this is owned solely by them. Again, especially if you're a married couple, and if you were to take property during your marriage as sole and separate property, it's probative evidence that it was supposed to be your separate property, but it will need to be proved the same in court, because we have a general presumption in court, in family court here, that everything purchased during or acquired during the marriage is presumed to be community property unless otherwise demonstrated not to be. Another unique feature is joint tenancy. This is a very old English common law way that you can take title to property, and we don't need to do all of the formalities that were required in the past. It used to have to be that everyone had to take title at the same time in union. That does not have to be the case anymore. But joint tenancy is a way in which we can pass on a right of survivorship again, and the individuals do not have to be married. So it can be a mom and a daughter, two cousins, sisters, whatever, two friends, but your intention is that when one passes, the property will immediately vest upon death with the other person. That is very important because many people I have seen in my law practice come in with a joint tenancy with rights of survivorship, and in their mind, they believe they have a tenancy in common.
Right, where they're 50-50 or whatever. It can be any division of percentages, but...
Right, correct.
Yeah, but yes, you are, yes.
So
correct.
when we, in general, if you were going in with an individual that you don't have some type of deep relationship with, that you want your interest to go to that person and you're not married to that person, but say you want to go into some real estate venture with that individual, the surest way to do that is tenancy in common at the very least.
Right.
Because that provides the person a certain interest that is their vested right as to the other, and they can leave their right to their heirs if something should pass, or transfer and sell their rights as they please.
Right, exactly. And like we mentioned before, that can be 50-50, but it could be 80-20. It could be any, division, depending on maybe one person put more money into the deal or what have you, whatever the two agree upon. That's
right. And it's usually should be reflected in the deed. You don't want to get into a situation where it says tenancy in common, because if it is not mentioned, it is presumed to be equal.
Right.
So we like to always put that into the deed itself.
Exactly.
We spoke about some estate planning
last time we got together.
And I wanted to let you know that we can also, as we know, put a real property into trust. For an estate planning purpose, or just to protect our assets over time. And so that's another way that we can hold title in Nevada. And lastly, a lot of investors will do this. You can also own title to real property in the name of a business.
Yes, like an LLC.
That's correct. And there's different structures that we can use. One popular structure for the real estate market is the Series LLC. If you have multiple investors and you have separate properties in a conglomerate deal, in order to keep them separate and apportioned apart, so there's no liability that flows from each property to the other.
Right, right. So if something happens at one property, your other properties are not endangered.
That's right.
Yeah, keeps that. It's like putting it all in little buckets.
Correct.
All little separate buckets.
That's right.
So that's good. Then a lot of people ask me then about homesteading, because they get confused between, there's, the way your property is vested, how you hold title, and obviously that has, consequences depending on, which way you choose. But then homesteading, which is just, was just only for their primary residence. What does that do?
Well, homesteading was a protection that was provided way back in the late 1800s. And it's recognized in different states in various forms, but Nevada homestead law allows you to file what we call a homestead declaration for your primary residence. So this is the home that you reside in. You can't file multiple homesteads.
Right.
And the reason being is they wanted to provide an avenue for an individual to not always fear that they're going to lose the house that you're raising your children in or your family's home and upset it. How can you lose your family's home? Well, through bankruptcy, through a lawsuit, where you're sued, through tax liens, all these various ways. And so it doesn't protect you from everything, but in the state of Nevada, if you file your declaration of homestead, pay your recording fee, it will, at this point in time, protect up to $605,000 in equity, which can be very beneficial if you were going through the bankruptcy process, or you were sued by a creditor and they have a judgment against you. They will not be able to attack up to $605,000 of net equity in your home.
Right, but it doesn't protect you from debts that you have agreed to, like your mortgage.
That's correct. Yeah. Anything that's liened or encumbered on the home is not protected.
Right.
Certain obligations such as child support, alimony, or even tax liens, when I had mentioned before, they would still be able to reach that equity if they needed to.
Gotcha. So people need to be careful with that and know that that is not a total protection.
Exactly.
So, well, and again, it's why it's so important to do the estate planning, get advice when you're deciding on the vesting on your property. And can you change the vesting on your property?
Typically, yes. You just need to pay attention to some of the exemptions from real property transfer tax, and we can talk about that maybe at another time and place.
Next time, absolutely. At $5.10 per thousand on the value of the home.
Right.
So even if there's not a sale transaction, they can still invoke that tax based on what the assessor feels your property is worth. So all important information. So thank you, Kerstan, for being here today.
You're very welcome.
Again, I'm Laura Harbison, broker-owner of Realty Executive Southern Nevada Properties, and this has been Real Estate Today, and with Kerstan Hubbs of Essential Legal Services. Our information is below. If you'd like to reach out to us, we'd be happy to take your questions anytime.
Thank you.